welcome back to La Belle Vie. So for the Dan Markel case, I wanted to do a quick summary of today's hearing. We got to hear a lot of the pretrial motions. So without any further ado, let's get to it. I'm going to start with Charlie's motions. Now, the first motion that was decided was this one, which was the defendant's motion to enforce the discovery deadline. That was denied. So this was the motion the defense filed last Thursday, which, if you recall, was within 2 hours of the Adelson's attorney filing their motion to reschedule that hearing to show cause. And remember, that's the hearing that's going to be taking place this Thursday, where the Adelsons or their attorney must appear and show cause why they are not complying with the state's investigation subpoena. So as mentioned in my last video, which I'll link above in case you'd like to check it out, the defense filed this motion to enforce the discovery deadline in an effort to preclude the state from interviewing Donna and Harvey because the interviews will now take place after the September 22nd discovery cutoff. Now, as I thought, I didn't think the court was going to grant this motion, and not surprisingly, they did not do so. It's short, it's to the point, but I'll just read a few lines, and these are the ones that I highlighted in my community post. So here, however, the circumstances of the state's attempts to interview the Adelsons strongly militate against the defendant's suggestion that the missed deadline can be reduced to mere gamesmanship in violation of the court's order on the eve of trial. The ability of the state to obtain sworn testimony from the Adelsons has been directly impeded by the back and forth concerning the Adelsons' intention to invoke their Fifth Amendment right pursuant to any questioning about the subject matter of this case. And the court goes on to say, look, if we were to grant this would be basically a pretrial suppression order. They were, I think, very concerned about being overturned on appeal. And so, in fact, this is the kicker. This would substantially impair the ability of the state to prosecute its case while also permitting the defendant to call witnesses at trial who were first listed at the discovery deadline. So it's like I thought, the court was not going to allow Charlie to have his cake and eat it too. So that was good to see. So that's the first motion. Now, the second motion I'm not going to pull up because it was reserved. It was not decided at today's hearing, and it's a biggie. It's the defendant, Charlie's, motion to suppress the electronic evidence, the wiretaps. So that's a really important motion, and we're just going to wait with bated breath to see when that ruling occurs. I suspect it'll be a written ruling just like this was, and I will be checking that docket. The third defense motion we're going to go over very quickly is Charlie's motion in limine. So I'm going to pull that up right now. Now, just taking a step back, a motion in limine is a motion that a party brings outside of the presence of the jury to obtain a ruling. It's done a lot pre-trial, which is what we're seeing here, but it can be done during trial. It's commonly used for rulings on evidence, and that's whether to keep it out, which is really common, or to keep it in. So Charlie had 5 matters in this motion in limine that were all seeking to exclude testimony at trial. So the first one was a biggie. They were looking to exclude the Dolce Vita recordings and the transcript. Now, the court granted and denied this in part. So basically, there was 3 parts of this. There was, first of all, as you'll see here, they wanted the entire enhancement excluded, not surprisingly, one of the best pieces of evidence the state has. They also wanted the opening comment on the enhancement to be excluded. And if you'll remember, here's the quote, "If they had any evidence, we would have already gone to the airport." And then The third was the use of a transcript. So what was denied in the sense that it will be allowed into evidence was the Dolce Vita recording, including the opening comment. So we will see the Dolce Vita recording in evidence, and we will also see, including his opening statement. Now, the judge did say that he will allow an instruction about the beginning of the recording not being available due to technical issues, but that's it. Now, unfortunately, the use of the transcript will not be allowed, so that the court granted Charlie's motion to exclude this. Judge Wheeler excluded this as well, so I wasn't totally surprised. I mean, I certainly think it helps when you have the transcript, but there's a concern that they're just going to read along and not rely on the audio evidence. And the audio is the best evidence, and that is what they need the jury to rely on. So it was an understandable ruling. Okay, so the next thing that Charlie is trying to get excluded in his motion in limine is hearsay testimony from Jeffrey Lacasse. Now, this unfortunately was granted. And I don't disagree with the court's ruling. Basically, the court found that this was inadmissible than hearsay or double hearsay. And this is a situation when you have a situation like X person tells Y person, and then Y person tells Z person what X said. And as you can see, it's kind of like telephone, right? So they didn't allow it in. Unfortunately, this is good testimony for the case, and these are the aspects that are excluded. It's not the entire Jeffrey Lacasse testimony. It's these four things, but they're probably the best parts of his testimony, right? One, that Adelson had looked into buying Wendy a television, but it was cheaper than a hitman. Now that they could get in through Wendy's testimony. Second was that Mr. Adelson had looked into the possibility of hiring a hitman to address the Markel problem. That's the conversation he allegedly had the week of the murder. So it doesn't look like that's coming in. Or he said it was chilling. The third thing that's not coming in, of course, is that Mr. Adelson described his dinner he had with Wendy back when she was after the murder and she was down in South Florida. I actually did a traveling video. It was closed, but I did show that restaurant. Uvia, I think is the name. That's not going to come in. And then fourthly, the fact that Mr. Adelson kept large amounts of cash in his home. So that can come in, though, through other ways. We know June begrudgingly testified to that. 2 out of 4, they'll be able to get in another way, but that was a little disappointing, but again, not surprising. Now, the third thing that Charlie wanted to have excluded was the divorce filings. This was denied. So that means that the state will be allowed to bring in the divorce filings between Wendy and Dan Markel. And then the judge, so this was kind of interesting because I felt the judge almost seemed to agree with the state's argument that it's not just a motive for Charlie and that the motive can extend in layers. It can be multi-tiered, which makes sense in a conspiracy case. So that was really, I thought that was good to hear. The fourth thing that Charlie wanted excluded was testimony about a call from his then counsel, so not Rashbaum, but an attorney he had prior, to law enforcement. I think that was to Detective Isom following Katie's arrest. This was granted, so the state will not be able to bring in this testimony. I honestly never really quite understood the importance of this. I don't know. I don't really see this to be a big deal, really. Now, this one is interesting. This is testimony from June Imchinda, and it's specific testimony. It's not all of her testimony. Statement that Donna allegedly made not soon after the bump that she made to June when they were on the balcony at the Icon, that she felt that Dan Markel was haunting her from the grave. Now, a funny part of the hearing was that, basically Judge Everett is really straightforward and no nonsense. I really like his demeanor. I like the fact that he seems very organized. I love the fact that his clerk seems organized. I've already noticed a difference with uploads. It's fantastic. So anyway, he's a very serious person, as he should be, but I just thought we got to see a little bit of his personality because he made a joke there when obviously it was clear that this argument Charlie's lawyer made about excluding it for hearsay reasons was not going to prevail, because the state pointed out that the testimony is not being offered to prove the truth of the matter asserted. It's not being offered to prove that Professor Markel was actually haunting her from the grave. And the judge made a funny comment there. He's like, unless you're a ghostbuster, I believe is what he said. It was funny. So definitely the defense wasn't going to win on a hearsay objection. And in what it goes to is Donna's state of mind. And this is the big but, and this is why I think the court's leaning towards excluding this, guys. And that's because of Rule 403. Rule 403 is an overarching rule in evidence that says that even if evidence is relevant and admissible, so here, it'd be admissible because it's not going to be excluded for hearsay reasons, and it's relevant. But even if it meets all those tests, it could still be excluded under this overarching 403 rule that basically says if otherwise relevant evidence can be excluded if its probative value is substantially outweighed by danger of unfair prejudice, confusing of the issues, misleading the jury. It could cause undue delay, wasting time, or it's just cumulative. It's just repetitive evidence. So for any of those reasons, a court has a discretion to exclude otherwise relevant evidence. And I think here what the court is concerned about is fair prejudice and potentially also misleading the jury. But in any event, the court reserved ruling on this to give the state a day to see if they have other forms of evidence that link this instance of this alleged, conversation on the balcony to Charlie's state of mind. Because as the judge mentioned, Donna's not on trial here. So the state's going to have to go back and try to find something to link this incident where Donna, her state of mind, and link it to him. Otherwise, I think the judge is going to grant this motion to exclude that evidence. I think that's where we're going to go with that. And then the last motion that Charlie had, I won't pull it up because it was kind of not a big deal, but it was denied. So I guess a kind of a loss for the defense. They had filed a motion to use this really extensive juror questionnaire. Now, generally speaking, I didn't really find anything too objectionable in the questionnaire. It's really more of a matter of practical matter, whether the court was really going to go through the effort to give this questionnaire to all these people and have them read was it really necessary? And that's where the court was going with its questioning. And so they denied that motion for the defense to be able to use that juror questionnaire. And I think that's because when the court asked questions like, okay, how did this happen in the past? And the state said, look, in the past, this was fine. We did individual voir dire. It lasted about 2 days. And the judge seemed that was an appropriate way to go. And so therefore they denied this motion. There's the defense motions wrapped up. Again, we still need the motion to suppress ruling. Cross our fingers that doesn't get excluded. All those wiretaps. Let's go on to the state. Now, the main motion that the state really argued today was their own motion in limine. So I'm going to pull that up now. It's the state's motion in limine. And this also includes, if you recall, an amended motion in limine where they added a few wiretaps. Now, as we just went over, Charlie's motion in limine was all about excluding evidence. The state has matters that in this motion in limine that they want excluded, but that they also want included. So it can go both ways. Okay, so we'll start with some of the things they want excluded. First is Luis Rivera's gang affiliation and prior bad acts. So here's all of their argument, and Essentially, this was granted. So basically, anything about the underlying facts about his federal RICO case, which was related to his gang affiliation of Latin Kings, is excluded. Anything about his Latin Kings association generally is excluded. And any bad acts, period, is excluded. And that's a normal, I expected that to be his ruling. So I wasn't surprised. Now, on cross-examination, the defense will be allowed to explore any bias or motive for Lewis's testimony, and they're allowed to explore conditions of his plea bargain. So the fact that there is a concurrent sentence, but that's it. And Rashbaum seemed to agree with that in the hearing. But then when the judge asked him how much he was going to explore the fact that the state sought a concurrent sentence, Rashbaum said he needed a sidebar because it would give away his defense strategy. So whatever Rashbaum said didn't affect the outcome because the judge granted the state's request that this be excluded. And I've been trying to think how this might factor in Rashbaum's defense strategy, and I'm blanking. So let me know in the comments if you can think of any theories that Rashbaum might have. Now, the rest of these were pretty quick. And in fact, several of these Rashbaum didn't have any objections. So for example, there were some bullets that apparently were found at Premier Health 5 days that had no connection to the bullets that were used to murder Dan. Rashbaum didn't have an issue about excluding any testimony about Luis Rivera's mental health. Jason Newlin, who is the investigator who works with the state's attorney, he's part of the state's attorney's office, and he's a critical person in the prosecution because he's the one that kind of knows all the ins and outs of the exhibits and the evidence, etc. He will not be sequestered like other normal witnesses, so that was granted. They also, the court granted a motion to exclude any evidence of DV between Luis Rivera and his ex-girlfriend / mother of his child. And that was about it. Oh, and then they granted the use of headphones in both the courtroom and the jury room for all of this audio evidence that we're hopefully getting in, right? Hopefully those wiretaps get in. Then we get to 7 wiretap calls. And this is also, wiretaps are also part of their amended motion to eliminate, where they just added some additional wiretaps they're going to use. Now, obviously, this is something the state wants included. I covered these wiretap calls in a recent video that I'll link below in case you're interested in watching that. Now, this was granted, but with a big but. It's granted pending the court's ruling on Charlie's motion to suppress the wiretaps. So we're just going to have to wait on that ruling on that motion. So it looks like it's going to be like all or nothing. And Judge Everett did mention he listened to all the calls, so I thought that was good to hear. So the last portion of the state's motion in limine is the use of demonstrative aids. And this was partly denied and partly reserved. Now, there were 3 basic things of demonstrative aids that the state wanted to get in. So this is an example of the state wanting to include evidence. They wanted the transcript of the Dolce Vita recording. They want a transcript of the Matsuri recording. That's the restaurant, the Japanese sushi restaurant that Harvey and Charlie went to 2 days after the bump, and the transcript of the wiretaps. So what was denied was the use of the Dolce Vita transcript. And we know that was denied. The court conceded, the state conceded that because the court had already ruled in Charlie's motion in limine that the transcript was going to be excluded. Now, the other 2 are reserved. Now, with respect to the Matsuri transcript, that's not yet available. Defense did argue that they view the Matsuri transcript just like the Dolce Vita transcript. Their argument is basically these transcripts fill gaps for the jury, which they shouldn't do. It needs to be the evidence needs to be evaluated based on the audio. Now, the state disagreed with that, but it's all kind of premature right now because we don't even have the transcript. So that's reserved for that reason. On the wiretaps, obviously, we don't know if they're going to be allowed in. So there's that's reserved for that reason. But if they are allowed in, Rashbaum generally said he's okay with the quote concept of a demonstrative regarding the wiretaps. So we'll see. And then the only two other motions that we had were the state's motion to compel. If you recall, this was about the defense when they listed on their exhibit list. They said impeachment and rebuttal documents, and that was basically all they said. But the parties kind of basically worked that out, and it looks like the information is going to be coming forthcoming, and the state actually withdrew this motion. So for now, it looks like there isn't any dispute with respect to that. And the last motion we have pending from the state is, of course, relating to the order to show cause regarding Donna and Harvey Adelson refusing to comply with the state's subpoenas. Of course, that wasn't held today because the Adelson's attorney is out of the country on business, and that will be held this Thursday. In the meantime, thanks so much for joining. And if you haven't already subscribed, if you consider subscribing, that would be great. I'm trying to grow the channel, and I really appreciate it. And thank you to my returning subscribers. Your support means the world to me. All right, have a great evening, and I hope to see you in my next one.